Are you watching your narcissistic ex manipulate Wisconsin's family court while you feel powerless? Most parents react emotionally, exactly what the narcissist wants. One outburst can damage your custody rights, so learn the step-by-step system that helps parents regain control and protect your children in high conflict cases. Well, hello, my name is Jeff Hughes and I'm the lead attorney for Sterling Lawyers. We are a large, exclusively family law firm in Wisconsin, and we see hundreds of cases and judges every single month, and that gives our clients an unfair advantage. In this video, I will share with you the 5 strategies to defeat a narcissist in a Wisconsin child custody battle. And I will show you how to methodically turn the tables on the narcissist and use their venom and their manipulative tactics against them while you maintain the high road and win credibility with the court. Okay, strategy number 1. Documentation is your strongest weapon. Think of documentation as building your case brick by brick. I will explain exactly what you need to do. So let's get going and creating a bulletproof documentation system. And there's 3 components to it. 1 is I want you to understand why. Why are you documenting? Number 2, I want you to understand how to do that. And number 3, I want you to understand what to document. Put all that together to create your documentation system. So why? Why are you documenting? Why go through this onerous task that can be difficult to do consistently and to do well? Okay, first, it is a tool. And here's how this plays out when you get into the real life aspects of your case. 1, it shows a pattern of behavior. Patterns are persuasive. They are hard to ignore. Individual incidents, they can be maybe explained away. They can, well, it's a one-time anomaly. But when you stack these up methodically and carefully as you prove your case, judges are persuaded by patterns. Guardian ad litem see them. They begin to understand them much more coherently than individual events. Standalone facts, they're not as trustworthy. Patterns, hard to ignore, much more persuasive. Okay, second reason why you document is 1, you use them as a tool to refute the false allegations that are coming from the narcissist or that have already come. Professionally organized and well-crafted documentation is a powerful antidote to false allegations from a narcissist. 3, it is a tool to refresh your recollection when you may have to testify or you may be in conversation with a guardian ad litem or a social worker or a therapist or a psychologist down the road. Now, understand that some custody cases can be over with in a few months, but some unfortunately can go years before they're over with. And in that amount of time, there are many events that happen, and you may need to look back and remember with accuracy what happened. Number 4, it is a fantastic tool to persuade judges, guardian ad litems, family court commissioners, social workers, because it shows that over time you have methodically and honestly kept track of these events, you've kept just the facts, and you've done it consistently and faithfully, and you can give that to one of these officials in an organized way. That's a very persuasive tool. Okay, that's why you document. Let's switch to how do you do that well? Okay, first off, do it on a computer. It is much easier to edit and, more importantly, organize down the road as you want to put it in a chronological order. So now if you don't have a laptop or a computer, you can use your phone, but do it in an app that is easy for you to organize because you're going to want to present that down the road, and it needs to be in a format that's easy to digest and to take in. Okay, along the way, your documentation should be simple and concise. And when it comes to your final product, less is more. Stick to the facts. Do not opine. Do not add your commentary. That is not important. That actually detracts from the value of what you are documenting. So stick with just the facts. You're also going to have to get into the habit of keeping records of everything, even if it seems minor. It is better to have it than not have it when you may actually need it. Now, I also want to tell you, and this is so critically important, that you do this consistently, is when you document, be honest. Everything you do goes toward your credibility. And in family court, nothing is more precious than your credibility. This is all about you persuading court officials that you are more credible than the other party, that you can be trusted more. So that means as you're documenting, if you do something that you're embarrassed of or that maybe you're ashamed of, document that anyway. Put the facts in there that is what happened. You wish you wouldn't have done it, but you did it. It is so much better for you to be the one to share that with the guardian, for example, than for the guardian to hear that from the narcissist and have it twisted and made to look even worse than it actually was. And if you can be the one to share that in advance when they do it, it kind of makes them look foolish sometimes. You also want to document chronologically in order of date and time. That is so much easier to understand and to put things in context and categorize them whenever it's done chronologically. Now, all along the way, it is imperative that you remember who your audience is. You are not writing to your mom, to your dad, to a family member, to a best friend. You are writing for a couple people and them only. Keep in mind, that is who you need to persuade. That would be the judge, the court commissioner, the guardian ad litem, the social worker, the therapist, the court-ordered psych evaluator if that's necessary, and maybe even you to refresh your memory down the road, or maybe even for your attorney. That is it. Write for those individuals only and put everything in there that may be of interest to them while doing it simply and concisely. Okay, let's shift over what. What do you write down? Always the date, the time of the day, the location of what happened, and what happened. Again, sticking to the facts and the facts only. If you have pictures, include that. If you have screenshots, definitely include that. If you have videos, make those videos accessible so whoever is going to watch this can access those videos. And where you can, for each of those entries, headline them so they're easier to find looking back for reference. And again, you're going to have to stay and get in the habit of saving everything systematically, text messages, emails, social media posts, all of that sort of stuff. Also, while you're doing this, it is always better for you to email than it is for you to text. Emails are easier to save. You can put more in them. They're easier to organize than text messages. Text messages can get really messy because now you're dealing with a bunch of screenshots, and that can be kind of hard on the reader. Okay, strategy number 2, master emotional management. This, my friends, is where many cases are won and lost. Now, here's how this strategy works. Let me make it very, very simple here. Follow the 48-hour rule. Unless it's a genuine emergency, wait 48 hours before you respond. And when you do that, respond strategically in this way. Make it a 4-part response: brief, informative, firm, and professional. So brief in that your responses should be minimal. Stick to the facts. Narcissists, they want to draw you into a long explanation that they can twist and manipulate and try to make you look bad. But if you stick with just the facts, there is less there for them to use, less fodder for them to twist and try to make you look bad along the way. So make it brief. Number 2, make it informative. Stick with verifiable facts only. Narcissists struggle to manipulate concrete evidence. That's really hard to massage. And when you're done, review it. Keep a draft first before you send it. Make a draft and review it for anything that comes across as emotional language. Make it firm. End with a clear statement. Make it clear. Make it firm. Narcissists, they hate boundaries. Courts love them. So make clear, unmistakable boundaries for that narcissist to know about and be expected to follow. 4, make it professional. Maintain a professional tone. This is so frustrating to a narcissist because they want to manipulate and they want to attempt to paint you as the one who's hostile. Do not be friendly. There's really nothing to be gained by being friendly. Just be firm and professional, right to the point, just the facts, businesslike, and keep it focused on the child. Strategy 3, build your professional team. Now, this starts first with getting a good, experienced family lawyer. I know you expect me to say that because I run a family law firm, but let me tell you, in a child custody case where the stakes are so high, it is imperative that you have access to a good legal mind who can help you put all of this together. Now, I know that could be really difficult for some folks to do that, but at the very least, consult with a lawyer, someone who's experienced in how the court system works. We have a saying in family law that it's important to know the law, yes, but it's far more important to actually know the judge, because they are the ones who interpret the law on the facts, and each judge is different on how they look at cases. And it's important to work with someone who has experience in knowing how that judge or that commissioner is going to respond. A second professional to help you is a mental health professional. Now, this is a therapist for someone who can help you process what you're going through and not distracted with the emergencies and the drama of the here and now that narcissist will inevitably create. Okay, one more aspect of this professional team. It is imperative that you be the one to take the initiative on this. Now, be honest with yourself. Some folks struggle with issues that they are not proud of. Now, one example of those would be alcohol issues. It is important that you control what is presented to the court. I would encourage you to be the one to take the initiative and go see a professional that can help you work through that, can help you get and stay sober. If you go before the judge and you just raise your hand and say, yes, judge, I have struggled there in the past, but I am doing something about it now to deal with it because I don't want it affecting my parenting. And I've been sober for 4 months or 5 months or whatever the case is. You actually get more credit and more credibility from a judge when you be the one to do that. And if that applies to you, it is the best thing for your case, and it is certainly the best thing for your children in the long haul. Now, also, as a part of the professional team, now this isn't the team that you create, but maybe not necessarily on your team, and that's the guardian ad litem. They are appointed by a judge for the benefit of your children's best interest. Their job is not to advocate for what your children want. That's not what they do. So understand their role, because you will be interacting with them, and their recommendation or their advocacy is so important to a judge. A judge doesn't have as much time to look into the nuances and facts and details of a case. So they rely oftentimes so much on a guardian ad litem. Okay, so let's talk about strategy number 4. Deploy your legal options when appropriate. I will try to explain to you on how you can do this well when it comes to your legal strategies. Number 1, in Wisconsin, we have what is called a temporary order. Now, that is an order entered by the court, and oftentimes by a court commissioner, by the way, but it's entered by the court in the early months of a divorce action. And it's the order that is to govern the parties' behavior and financial payments and those sorts of issues during the pendency of your case. What is entered is not final. It is just to get you through the case. And a lot of times parties need these because they're great when you need to establish temporary physical placement. They're very good when you need exchange times and locations, and you may need communication with the other party and they're not communicating. So getting a temporary order that requires communication through some app, for example, that is a really good use of temporary orders. Certainly they're important for financial matters as well, like child support and other bill paying and that sort of thing. Another financial tool are modifications. Whenever you need to modify that temporary order. So know that just when the order is entered doesn't mean you can't come back later and request the court to modify that during the pendency of your custody battle. Now, it is important that when you file that modification, you show that there has been a change in circumstances since the last time the court's order was entered. That will help you get a hearing with the court to get that order changed. So another tool are emergency actions. Wisconsin courts do allow emergency motions when there is an immediate danger to the child, when there is a substantial interference with placement rights, meaning the other party is withholding the children from you. Maybe they've left the county or the state, for example, or when there's evidence of significant parental alienation. So those will allow someone to request an emergency motion and be heard and get a temporary order to alleviate one of those things or all of those things if necessary. Another tool is a restraining order. So if you have been harassed or threatened or physically harmed by this narcissist X, you can get a restraining order. And there's ways to file that and do that quickly. If you want to go reference Wisconsin Statute 813.12, that will help you understand what is necessary and how to go about doing that. You can go to the courthouse and request paperwork for that, and they'll certainly help you and aid you in doing that. All right, the fifth and final strategy, when you get to court, dominate. And let me explain how you go about doing that. Your court appearance strategy is crucial. So here's how you can handle yourself effectively and present your case persuasively in family court. Number one, preparation. So prepare by bringing organized documentation in chronological order. Have it concisely summarized of key events. Be prepared to provide specific examples of concerning behavior. Don't just give broad blanket allegations. Provide concrete, very specific examples, date and time if necessary, and bring copies of all of the relevant communication. That should all be organized in one folder. Bring a copy for you, bring a copy for the judge or court commissioner, bring a copy for the opposing party, and the guardian ad litem if a guardian is a part of the case at this point. Okay, let's talk about the actual presentation while you are in court. First off, remain calm. That could be hard. Practice that. Remain professional regardless of the provocations, and you will hear them. They will come fast, they will come furious, and you will have a burning desire to want to tell your story. Slow it down. You will get that opportunity. Speak to only when addressed. Do not interrupt the judge. Do not interrupt the commissioner, and do not even interrupt the opposing party. Stay calm. The judges and commissioners see this all day long, and they appreciate it, and they give credibility to parties who stay calm. When you do talk to the judge or commissioner, address the judge or commissioner as Your Honor. Your Honor this, Your Honor that. Be very respectful. Say that slowly. Focus on your facts, not your emotions. Avoid opinion. Avoid play-by-play. If the other party interrupts, and they're a narcissist after all. They're likely going to do that. Ask the judge politely, Judge, I was respectful whenever she or he talked. When I speak, I would ask the court, order her to be quiet and let me present to the court as well. Something along those lines that comes across as respectful to the court, certainly. And if they interrupt again, that's going to start to piss off the judge or the commissioner. Also, I want to point out to you that our judges, our commissioners, our court officials are required to follow the law as a framework when it comes to custody and placement issues. And it is so important for you to understand and be very familiar with what that law says. And I'm going to point you to the most important one, and that's found in Wisconsin Statute 767.4. Number one, the wishes of the parents. Yes, the judge will take into account what you want and what the other parent wants. The judge will take into account, when appropriate, the wishes of the child. And that does not mean that the judge is bound to follow the wishes of the child, but they will consider that when entering their order. And so much of that depends on the age and the emotional and mental maturity of the child. The court will also take into account your relationship with your child. They'll take into account the other party's relationship with the child. They'll take into account the siblings, any siblings involved, their relationship with each other, as well as anyone else the court deems important to the children. The court will take into account the amount and the quality of time that each parent has spent historically with the children. The court will look at any adjustments to home, school, and community that need to be made and consider those things when entering their order. They'll look at the cooperation and the communication and the collaboration between you and opposing party. If they find that one person is not cooperative or communicates in a destructive, non-helpful way, that will be used against them. The court will also look at the mental and the physical health of both parties. And if that party is a narcissist and over time you can prove that through patterns, that goes to their mental health for sure. The court will look at the availability of childcare, whether that's with you or with a third-party provider or another relative or something like that. The court will also look at whether either party has engaged in patterns of spousal abuse, domestic abuse, battery of any sort. So please get familiar with all of those factors. Understand how the courts look at cases through those lenses. Now, the Wisconsin family court system will recognize patterns over time. Stay focused on your children's well-being. Stay focused on the long term, on the big picture, without getting distracted by the drama and the tyranny of the moment. Maintain your documentation. Work effectively with your legal team and your professionals. And most importantly, stay calm and centered. You can do this. You can get through this. You can prevail, even against a narcissist. And if you found this video helpful, I recommend watching our next video, Tools for Co-Parenting with a Toxic Ex. It builds on what we've covered here and gives you a practical strategy for day-to-day interactions.